So good morning, everyone. For the record, I'm Matthew Cherry, TABC's Senior Counsel. We have 3 agenda items today. Before we get started on those, I'll just kind of explain the lay of the land here. So the purpose of today's meeting is to provide an avenue to stakeholders and the public to provide verbal comments on these draft rules before staff actually presents these rules to the commissioners to vote on at the next upcoming commission meeting. Our intent is to propose these rules at the upcoming meeting on November 18th. If the commission does vote to formally propose the rules, there will be an additional public hearing similar to today's stakeholder meeting that will also provide another avenue for stakeholders in the public to provide verbal comments, and there will also be a written comment period, all before the agency moves forward and potentially adopts all of these rules. Today, also, I'm just going to add, is not the only opportunity to provide any feedback on today's drafts. You can make verbal comments. You can also supply comments in the chat. And then as well, after the conclusion of today's meeting, you can submit written comments to the agency. We do request that you submit any of that written feedback by Monday, November 3rd, just in order to give the agency and staff some time to discuss any of those comments internally, potentially make any changes before we actually propose the rules to the commissioners at the next commission meeting. So with all that said, I will get started on our first agenda item. So the first item up is item 1, which is revisions to rules in Chapter 41 pertaining to auditing. Here we go. So the first one is 41.37. And so all we've done here is we've just removed a citation to a statute that has been repealed. And the next is 41.43, subsection A. And here we've just removed the in bulk requirement for inventory sales once a license or permit holder has gone out of business, potentially due to a voluntary surrender of their license or their permit, or cancellation or something like that. Currently, the rule does require that all of that inventory sale happens in one mass group in bulk. The agency feels that this is a good time to add some flexibility in there, so that way license and permit holders may sell a certain amount of their inventory to one individual and then the rest of it to someone else. The next change we have is in Rule 41.50, subsection B. This is just fixes a clerical error. That word B that's struck through does not need to be there. The next revision we have is in 41.52, subsection B1. And all that we're doing here is just clarifying the requirements for private club temporary membership cards. This is not a substantive change. Everything that all current practices remain the same. This just adds some clarity and makes it clear that that holder of a private club registration permit must also purchase and maintain those temporary membership cards as well as issue them to the private club members. The next revision we have is in 41.53, subsection E. What we've done here is just moved this to a new rule in 41.57. And then as you'll see in 41.57, that is almost identical to the prior text that was just moved from 41.53. It has been slightly reworded for clarity, but there's no substantive changes here. And next we have 41.65. And what we've done here is just added a clarifying statement to make it clear that wholesalers may pick up product from a contract distiller's facility. So for example, if distiller A hires distiller B to produce product on behalf of distiller A, that product does not automatically have to go back to distiller A's premises for the wholesaler to pick it up at distiller A's premises. That product can remain at distiller B's premises, and then at the direction of distiller A, they can work with that wholesaler that they're selling the product to, and the wholesaler can go directly over to distiller B's premises, pick up the product there, and then transport it and move it down through the 3-tier system. And that covers item 1. So for now, I will open the floor to any comments on this first agenda item.
Matthew Marcus Schwartz. Good morning to you, sir. On the very last contract distilling, with the clarifications the wholesaler can pick up, I presume that there's no issue with common carriers as well, like the FedExes of the world, to pick up and deliver to qualified persons outside the state. I don't know if you want to add that, but while we're clarifying, just, you know,
that's a good comment. Yeah.
Thank you.
Thank you. All right, I don't see anything else, so we're going to move on to item number 2. So the next agenda item covers revisions to our rules on cash law and credit law. So this is rules 45.130 and 45.131. So the first revision we have is in 45.130 subsection B7. And all we've done here is just updated that list of applicable permit holders. There's not a substantive change here. This just tracks better with the actual statute in the code. And next we have revisions to 45.130C1. What this does is just add the identification stamps to the invoice information requirements. And then next is 45.130 subsection D subsection 1 and D1 as well as D4. And what we've done here is added in business days to the rule. And this is based on a prior comment that we received from the most recent rule review of this subchapter. And then are some other changes here that are not substantive. It's just some grammar and kind of fixing some of the words, so better readability. And then next we have a change in 45.130 subsection H2 and 3. And all this does is one, fixes some clerical errors, and then provides some clarity on removal from the delinquent list. That way it aligns with longstanding practice that the agency actually does approve any sort of dispute that's going on before a business's name is removed from the delinquent list. And so here what we've done is added that approval, and it can be approved either by the executive director or the executive director's designee. And then next we have changes to 45.131. The first one is in subsection B7, subsection A. And this is very similar to what was just done above in 45.130. All we've done here is updated the list of applicable permit types to better track the statute, and this is not a substantive change. And then last, what we have for this agenda item is changes to 45.131 subsection C. And all we've done here is just fix some of the grammar in the rule. Again, no substantive change. This just provides some clarity for better readability. And that covers the proposed changes for the cash and credit law rules. And I will now open the floor for any comments on agenda item number 2.
Hey, Matt, this is Edgar Korzanowski from Griffith and Hughes. I have a few comments, if it's all right.
Absolutely.
Sure. So I'm going to go over the things that are, I think, missing from the rules, and then maybe one or two things that might be needing some improvement. First of all, the rules don't address bankruptcy code implications. One of the concerns I have is TABC still has this disclaimer that says, well, notice regarding bankruptcy whenever you go and look on the credit list. This kind of practice was struck down in the Gabriel bankruptcy decision, and we think the better approach is just have a rule that's very clear. If somebody is in bankruptcy, they're not put in the credit list, and that the appropriate exemptions are made to the rules. So ask that the commission consider that. Another thing that we would ask is that this is specific for 45.130 D5. This is the one where if there is some sort of delinquency, it follows any new applicant who may have been associated with a prior entity. The issue there is I don't think that this is consistent with other law. I mean, the Business Organization Code doesn't allow personal liability for managers or members of an LLC. Similar idea for corporations and things like that. Yet, the TABC seems to ignore that and allow the debt to follow any new entity if it happens to have an existing applicant. So we just ask that the commission consider revising the language on that that basically allows or considers the business code or some other legal provisions, so it's not following again a new applicant. And bankruptcy and things like that, change of business, this is kind of a trend, partly because of COVID, and I think it unfairly punishes package stores, for example, or somebody else that wants to go and start up. So again, we'd ask the commission to consider that. We did submit written
Edgar,
comments.
can I ask one quick question? So it wasn't clear to me. You were talking about 45.130. Was that B5 or D5? So
D is in dog. D5.
There we go.
And
okay, thank you.
And as I said, I have submitted written comments, but I just kind of wanted to highlight that. And then finally, one thing that I think the commission could do better on as far as the credit law is require that there be evidence of the credit law violation to be provided on the front end, much like you do with the wholesaler permits. That there's copies of whatever documents, so whether it's return checks or evidence of a debt, include a copy of the invoice, because sometimes there may be some matters that are on the invoice that have nothing to do with liquor, and we don't want to have a situation where somebody is wrongly accused of violating credit law when there isn't in fact a credit law violation. That's all. Thank you.
And we appreciate the comments. Thank you. Is there anyone else that would like to provide any feedback or comments on agenda item number 2 pertaining to some proposed revisions to the agency's rules on cash law and credit law? All right, I do not see anyone at this time, so we'll move on to agenda item number 3. So number 3, this pertains to some new rules on the sale of consumable hemp products. These rules are being proposed to implement Governor Abbott's directive in Executive Order GA-56 to prohibit the sale of consumable hemp products to minors. And as you'll see, the text is based off of the agency's emergency rules that were just adopted at the last commission meeting, and that is emergency rules number 51.1 and 51.2. As directed in the governor's executive order, TABC is currently coordinating with the Department of State Health Services. And today's draft rules pertain to the order's directive only on age gating and ID verification. We will not be covering anything about any sort of labeling or testing requirements. Just as a reminder, all of that is handled by the Department of State Health Services and not Texas Alcoholic Beverage Commission. I do understand that there's going to be probably a lot of questions surrounding the scope of some of these rules. However, I do want to remind everyone that the purpose of today's meeting is to receive comments on the rules in the rule text before we actually present them at the next commission meeting. And before getting into the text, there's just a few additional comments that I'd like to make. TABC's rules only pertain to license and permit holders of a TABC issued license and permit. These drafts do not apply to businesses that only hold a license or registration with the Department of State Health Services, who do not also hold a license or permit issued by TABC. Additionally, in terms of specific product types, these rules do relate back to the definition of a consumable hemp product that's found in the Health and Safety Code and the rules issued by the Department of State Health Services. However, the agency's focus is on intoxicating products. And with that, I will get started on first draft of the first rule. So this first one covers prohibited sales of consumable hemp products to minors. As you'll see, subsection A provides some definitions, and then subsection B actually sets forth the prohibition on selling, offering to sell, serving, or delivering a consumable hemp product to a minor, and then it relates the violation back to the place or manner provisions in the Alcoholic Beverage Code. And I will add that the agency's focus here is on the sale, service, or delivery to an ultimate consumer. The focus is not on transactions that are happening between businesses, for example, like a manufacturer to a retailer. And then next in subsection C, this just sets out the penalty of cancellation. And last, what we have here in subsection D, it explains that TABC will not hold a license or permit accountable for selling, offering to sell, serving, or delivering a consumable hemp product to a minor if 3 things occur. First, the minor presents an apparently valid identification that complies with the ID verification rule that we'll go over next. And second, the permittee or licensee actually inspects the identification as provided by the next ID identification rule. And then third, lastly, that the permittee or licensee reasonably believes or reasonably concludes that the purchaser or the recipient is actually at least 21 years of age or older. And that covers that first proposed rule. And then in the second one, as you'll see in subsections A and B, we require the TABC license and permit holders to inspect a person's ID and actually verify that they are 21 or older before actually completing the sale, service, or delivery of a consumable hemp product. And then next in subsection C, it sets forth the penalty of cancellation for a violation. That covers both of these rules and the third agenda item. And so with that, I will open up the floor to any comments.
Matt, this is Edgar again. Real quick question on the under mandatory age verification. There's the thing about valid and expired proof of identification. How does the commission intend to deal with digital IDs? I understand there's about 17 states that do use those. What's the commission's take on that for this
I
one?
would have to have, yep, I will have to have a discussion. I'm not aware of Texas actually going forward yet and authorizing the digital IDs like other states have.
Okay, so I guess the question is there going to be a full faith and credit if, somebody say comes from New Mexico with their, digital ID? Is this going to be resulting in a ding if they present that? Does that make sense?
That does make sense.
Okay.
I will note that down and we'll discuss internally. Thank you.
All right, and then just one more follow-up question. What about when DPS gives the temporary, driver's license? Let's say you've lost yours or whatever, and you get the paper printout. Is this going to be also covered and, fall under valid or not? I'm not asking whether you have an answer right now, but, it's a rhetorical question.
Right. Nope. I understand. Yeah. I'm making a note. We'll discuss that.
All right, thank you.
Hey, good morning. This is Robert Schaefer at Total Wine. I had a question about subsection C in the first rule, and in particular the mandatory cancellation of the license. So I wanted to maybe ask a question about whether the commission has considered whether it's consistent with its other practices on licensing cancellation and revocation and suspension if there's no hearing or due process opportunity by the permittee to present whatever evidence is appropriate about the alleged charge of sale of THC products to a minor. So that's one question. And the second one is related because I noticed that Health Services had issued some preliminary rules, draft rules, I think. Now, that's on the hemp license side of the equation, but they do seem to contemplate a hearing and opportunity to be heard by the permittee before the hemp license is revoked or canceled. And so that just seems a little bit different than the approach taken by the commission, but both in the rule and in the current text of the code.
Okay, nope, I fully understand what you're saying. Some of that might just be due to the different ways that Dishes ends up putting language in their rules versus TABC's. I mean, if you look throughout our rules, there's multiple instances where it talks about a violation and it doesn't reference the hearing process. So that hearing process actually comes from our code, which prohibits the agency from taking an action on a license or permit without giving due process and providing that opportunity for hearing and the opportunity to present evidence. So I will add that just for clarification for everybody, even though that you do see a violation of cancellation mentioned in these draft rules, that is not something that's going to happen automatically. It will always go through the normal process. TABC would make a case, send over a notice of violation to the license or permit holder, give that license or permit holder an opportunity to go to a hearing, and then everything would happen through that normal hearing process in front of SOA.
Well, that would be great if that could be clarified. Thank you so much. And then just one sort of follow-up question, somewhat related to this topic, and I really just throw it out for your consideration, and that is that the way we read the rule, it kind of says that you have to card everyone and you have to inspect everyone. And I think, the commission has always been very helpful in trying to look at its rules and its laws in the light of operating a business. And you can imagine in a busy liquor store, you have people trying to get through the lines. You have someone who's 70, 60 years old, or obviously of age in order to purchase these products. And you can imagine how business would be affected if every single person had to be ID'd, every single ID had to be inspected or scanned. So I just wonder if, the intent of this is to say you must ID everyone who purchases these products, including people who are obviously of age, and whether that, there would be a way to clarify that that's really not the intent here. The intent is that you have to ID, people who look like they should be ID'd. Most businesses have rules on that, but, we're just concerned about believe it or not, some older people get offended when you ask them for their ID. They're like, "What are you talking about? Have you looked at my hair? It's fully gray, or I don't have any hair, or whatever the case may be." So I'm just kind of wondering if the commission took that into consideration when it drafted the rules, and whether the intent is really to have every single person carded when they come through a store.
Okay, I'm going to note down your comment. As of right now, the way that the rules are written, it does require that ID verification on every individual sale. But I will note down this comment and we will discuss internally before we actually propose these to the commission. So thank you.
Thank you.
Matthew, I had some follow-up on Bob's comments. Dewey Bracken here.
Yes, good morning.
Good morning. I think, obviously the due process, I agree, would be required under the Administrative Procedures Act and the Texas Code. But I'd also like the staff to look at Section 1164A. That's the alternatives to suspension and cancellation is how that's styled. And that says the commission shall give folks the opportunity to pay the civil penalty. And then there's a statutory list of sections of the code where that civil penalty does not have to be offered. And so just statutory authority wise, look at 1164, because I do think that this rule might overreach that current statute. Maybe a reference to section 1164 in this rule. Also in 1164, there's 1164B and C, which talks about the commissioner administrator has discretion to relax the provision of the code in cases of entrapment, exercise of due diligence, happen without the knowledge of the permit holder, those types of things. I think we might get some unintended consequences. There's the hemp seed cream, that facial cream, is technically a consumable hemp product for which grocery stores and pharmacies have to register. It has no psychotropic effects whatsoever, but you're required to have a consumable hemp permit in order to sell it. And a lot of these grocery stores and pharmacies have TABC permits. So to not card an 80-year-old lady for face cream and then lose your liquor license, it seems a little extreme.
Understood. Thank you for the comment.
Hey, y'all. This is Shelton Green. I wanted to first thank you for the opportunity to have the stakeholder back and forth. Really appreciate it. Just a quick kind of like logistical question. Would you walk through the timeline for when y'all would like to receive comments, and then also when you'll be proposing the rules, and when would the 30-day comment period be, and when would the ultimate kind of like, target for adoption or not adoption be for TABC?
Yep, absolutely. So in terms of written comments for the current drafts that we're reviewing today, our request is that everyone submit any of their comments by November 3rd. Next step would be we intend to look at those comments, potentially make revisions to this draft language, and then actually present these rules to the commissioners at the November 18th commission meeting. At that point in time, what would happen is the commissioners would then vote to either not go forward with the rules, or they would vote to formally publish those rules in the Texas Register. If they do vote to publish the rules and then they're presented in the Texas Register, then there would after that also be a 30-day formal comment period where people can make comments. And then after that period, there would be another commission meeting that the agency would move forward with and propose whatever language happens after all those comments to the commission again. And then that would be for adoption. So that's kind of the main timeline. So the biggest dates right now would be comments on today's draft. Please get those in by November 3rd. And then after that, next step would be the commission meeting on November 18th. And then everything will play out from there. And during that commission meeting and all the documents that we put out, we'll make sure it's very clear those timelines are kind of communicated to industry and members of the public.
Thank you very much. Appreciate it.
Absolutely.
Hey, Matthew. Matthew, this is Mark Bordas. I'm here today on behalf of the Texas Hemp Business Council, and I just want to echo some of the concerns that have already been raised about compliance and market impact, specifically the chilling effect or de facto ban, and the heavy-handed treatment with license revocation. one and done would seem to really give people a cause to pause in carrying these products. I don't know if that's intended or not. And then the second one that was raised by Mr. Bracken, the definition of consumable hemp products, we want to make sure that the definition does not sweep in benign products such as CBD wellness and hemp seed ingredient products. So thank you, and we'll be submitting written comments.
Perfect. Okay, thank you.
This is Bob Schaefer again. I apologize for jumping back in. I thought maybe I'd give the floor to others, but I just wanted to maybe put another finer point on the comments I was making, and that is that the regulations seem to contemplate taking away an alcohol license for an activity that is unrelated to the sale and display of alcohol. And I wonder if the better approach would be if there is a violation of the prohibition on selling hemp products to minors, whether the appropriate punishment would be cancellation, suspension, revocation, etc., of the license related to that product, which is the hemp license, not the alcohol license. You know, it's one thing to cancel someone's alcohol license for violating the alcohol laws. This seems like you're trying to cancel the alcohol license for something that is related to the hemp license. And so, you can't sell hemp in a liquor store without the hemp license. And I just sort of posit the question whether the appropriate penalty, it would be directed at the hemp license as opposed to the alcohol license.
Thank you for the comment.
Sure.
Good morning, Matthew, Amy Harrison. I
Good
just
morning.
want to go back a little bit to Mark's comment and the fact that there's obviously a lot of confusion in the industry, and we've gone from no regulation to basically one strike and you're out. So many permit holders, TABC permit holders, are going to have to weigh the liability to their alcohol permit should they choose to sell the hemp products. And in essence, that might derive in less hemp business within the state and squashing out that type of business. With the confusion that's coming about, perhaps in the new rule under B and D, the commission could slide in the word if the licensee or permittee intentionally sells or offers to sell, serve, or deliver. And then in D, if a license or permittee that intentionally sells or offers to sell, might bring a little more comfort to those permit holders, because I don't believe the majority of them ever intentionally want to put hemp in the hands of a minor. So that wording could perhaps bring a little comfort to those that are obviously quite nervous about this. Thank you.
Understood. Thank you for the comment.
Hello, this is Heather Fazio with the Texas Cannabis Policy Center. I agree with a lot of the comments here and appreciate them being addressed. Another question about additional rules down the line. You mentioned that you're specifically writing rules about age restrictions and the enforcement of that, and everything else is DSHS. Do you anticipate additional rules from TABC down the line before the next legislative session?
I'm not sure at the moment. A lot of this obviously is in flux. This is just our first step into this. So as of right now, this is all we are intending to do. If the agency has any intent to move forward with any additional types of rules in the future, we'll be sure to update industry and the public. That way they can be aware of any upcoming stakeholder meetings. And again, if we do propose anything additional, we'll always have these types of meetings that's open to the public, where everybody can be very clear on what text that we're proposing and provide all of their feedback.
Thank you very much, and I appreciate the transparency and dialogue with the industry on this. Thank you.
Absolutely. Thank you. I'm not seeing anything else. I want to.
Hi, this is Jay McGuire with the Cannabis Retailers Alliance for Texas Craft. In the executive order Governor Abbott issued GA 56 back on September 10th, his preamble lists that his detailed approach would include requiring a retailer to scan the purchaser's driver's license prior to completing the sale for such products. But I note that your rules don't refer to that. Could you perhaps comment on that or maybe get into it a little bit with us as you go through the process?
As we go through the process, we definitely will. I will say, as of right now, the way that the rules are drafted is it's not about specifically scanning, but it is about verifying and checking that ID physically with your eyes, inspecting it, and then verifying that the person in front of you meets all of the information that's contained within that identification. So at the moment, this is not a scanning requirement.
Understood. Thank you, sir.
Thank you.
Matthew, Marcus Schwartz with Bracken Schwartz. I very much appreciate your, I'll call it your preamble, where you noted the agencies aiming this at retail to consumer transactions and intoxicating product. I think those are both important. So otherwise, you've got FedExes, you've got package stores, you've got wholesalers, distributors that deliver this product, and a lot of our retailers have employees that are under 21. And so I would say that I think these rules can be tightened up. For instance, in the latter section, subsection B, you note ultimate consumer versus everywhere else, it's just a minor. So maybe a minor who is the ultimate consumer, to make it clear that we are going after, or, you know, your end is going after the sale to the ultimate consumer and not just a delivery of product to somebody to resell. And secondly, on the intoxicating product front, again, I think it would be advantageous to clarify that in the rule that this is going after intoxicating products, because as has been discussed, there are face creams, shampoos that have been on the market for decades and never been an issue because it has zero intoxicating. But when all this new rule came online and the new law with the Farm Bill, those products got looped into it. And I don't think that's a concern, and certainly not something that a retailer should lose their license over for not carding somebody for shampoo that doesn't do anything.
Understood. Thank you for the comment.
Thank you.
Good morning. I've got a comment. This is Andrea Steele with the Banks Law Firm. And listening to the comment that was just spoken about the focus of the agency, I would suggest that perhaps the agency add to this rule that there's opportunity, or maybe the way for the agency to implement enforcement priorities, so it's clear to the market who you're targeting, and whether that's either something you put forth in these rules or refer in these rules to an enforcement priority that would be set forth by the agency on the website or some policy guidance, but somewhere so that the market knows who you are focusing on and that it's written down somewhere.
Understood. Thank you for the comment.
Thank you.
Matthew, one more comment or question. And it relates to the issue of the hemp license versus the TABC license. I understand that there is a MOU between Dishes and TABC, and I think food for thought, right? As part of that MOU, maybe it's TABC enforces the revocation of the hemp license versus the regulation or the revocation of the TABC license. I think that makes more logical sense. But as you're negotiating that, I think that would be wise.
Understood. Thank you. All right. Do we have anyone else that would like to provide any feedback or comments on agenda item number 3? I'm not seeing anything at this time, so now I'll open the floor back up. Does anyone wish to provide any feedback or comments on agenda items 1 or 2?
Matthew, Amy Harrison. The only thing I would probably suggest, particularly for agenda item 1, is that it be reviewed with electronic submission in mind for some of these reports, and the fact that we are trying to, there's a lot of language that to me pertains to how you print something out, how you have to sign it, how it has to be mailed, things like that. And if we can just think in terms more of aims, perhaps that would be helpful, particularly when it comes to terminology. Like no longer is there voluntary suspension, but temporary surrender, just so that terms line up with the way you have to treat things in aims. Thank you.
Thank you. Noted. All right. Would anyone else like to provide any comments on any of the agenda items that we've covered today? All right, I'm not seeing anything. Just as a reminder, so it is TABC's intent to propose draft rules at the November 18th commission meeting. After those rules are published, and if the commission votes to publish the rules in the register, there will also then be another formal public hearing to receive any verbal feedback. There will also be a 30-day formal comment period where written comments can be submitted. In terms of providing comments on the drafts that we covered today, again, please try to submit those by November 3rd. And those written comments can be submitted to the agency via email to rules, RULES, at tabc.texas.gov, or by regular mail to TABC at the Office of General Counsel, and that is P.O. Box 13127, Austin, Texas, zip code 78711. And I'll also add that all this information is posted on the agency's public website. So at this time, this will conclude today's stakeholder meeting. So thank you everyone for your time.